Yes?
Yep. I see.
Okay. And I'm gonna make it full screen, and just let me know verbally if it works. You can see it okay.
We're seeing it. So, yep. All
Yes? Okay,
there.
excellent,
Yep.
excellent. So we should have the presentation and most of the screen, and then I wanted to mention the little panel with all our faces on it, or if you're not on video, then of course it just has your name on it. You can expand that or contract it. If you just grab the sides of it or the top or the bottom, you can make it bigger or smaller. You can make it a ribbon on the side, you can make it full page, whatever you'd like. And if you kind of wiggle over it, it gives you options at the top for the size of the tiles. And if you wiggle towards the bottom and stretch it out a little bit, it gives you all those controls. And if you don't have all the controls because your window's kind of small, when you wave it, there's a little red box, click it, and it'll expand it and give you all the controls on there. And that's where the chat box is and some other things. So just so you can kind of know how to get around. It's pretty user friendly. Well, good. Well, thank you for being here today. Today we're going to talk about the fur bar contract and the closing. We're going to go over all the hot spots and important parts that are on the contract that have to do and affect with the closing, so that when you are out there, whether you're on the listing side or the buying side, and you're dealing with your customers and the lender and the closing agent, you kind of know the ins and outs of all these things, which helps you to deliver a higher level of service to your clients and customers, and also protect yourselves and your clients. So it's all good stuff. Um, like Tracy and Rose were saying, we're here for you. Any ideas that you have for topics or classes, please let us know. Know that the situation we're in right now is not forever. And probably the most important thing you could do right now is to keep on communicating with your clients, at least virtually. And that's something that's very, very important. This will be over. And what I want you to do is I want you to be in a position when this is over that you have kept that relationship going, that you've built a relationship virtually. So then you're in a position to list or sell at that time. So super, super important. I am developing a class based on that, and I'll get that information out to Rose and Tracy. They don't know about it yet. It's something new that I'm developing that'll be available at the end of next week to be presented. And hopefully we'll do that at some point in the future about communicating virtually with your clients. Well, great. So we'll get started. We are very lucky in the state of Florida. We have the fur bar contract, which is, in my opinion, probably the very best contract that I see out there. I get to deal with all sorts of contracts in different areas, sometimes in other states. And this is probably my favorite contract. I think it truly covers all the different pieces of the puzzle in the best way possible. And this is a joint effort between Florida Realtors, which of course you're very aware of because most of your members and your brokers are, and the Florida Bar. So it's a joint effort between the realtors and then the attorneys in the state that created this contract and started a long time ago. The good thing about this contract is that it's always being updated. And they have been meeting for a while, and we're probably going to see a pretty, you know, prominent update coming up. And I don't have the magic 8 ball to tell you when, but I'm going to hope it's later on this year at some point, with some changes to different clauses that we're used to make it even better. But for now, this is what we're doing. And this is, of course, the revision. And I'm going to use the regular contract, but if you go along with the as is, most things are very similar in that contract also. And I'm going to use the revision of 4/17. So April 17 was the last major revision. There have been a couple other revisions that didn't affect us in other parts of the state. Like there was a Miami-Dade revision for new taxing laws they have down there, but that doesn't affect us here. So this is pretty much the contract that we're still dealing with, but we should get some updates hopefully soon. The one of the things I wanted to mention is recently, and this is not for the fur bar contract, this is just for the Florida Realtors contract. The Florida Realtors has a standalone Florida Realtors contract, and then we have the Florida Realtors Florida Bar version, which was the most popular one we're going to talk about today. But on the Florida Realtors side, and of course you can use the addendum, and I'm sure your brokers have shown it to you already. We do have a COVID-19 addendum that was published, I think, 2 weeks ago. And that addendum covers extensions of closing dates and other issues related to the contract in case there's a problem and we can't close at this point because of what's going on. So, and I'm sure A lot of you have dealt with that already, but it's a pre-written addendum to extend dates within the contract with limitations on extension of those dates. So that's something, if you haven't seen it, you want to make sure that you look at. Let's get started. What I'll do is to let you know kind of what area that I'm in. I'm going to give you the section number, and everybody's contract is a little bit different as far as the page numbers, so I won't give you that. I'll just follow along with the section numbers and kind of where I'm at in those sections. And if you do have a contract and it's a blank copy, feel free to write on it, take notes, make a master copy. If not, just take notes and you can go back and reference it. I believe that one of your most important products that you're selling is your contract. So it's something that you really need to know, not in your head and know everything that it's about, but I want you to know if there's an issue or a problem, where do I get the answer in my contract to direct me what to do in that situation? So that's probably the most important thing. If you have never read through a contract, I suggest that you do it little by little. You don't have to spend hours and, fall asleep while you're reading one day. Do it little by little. Once a week, let's say every Friday from 2 to 3, I'm going to do a contract review date. And before you know, you have read the whole contract. Make up a working copy, a file where you're going to put notes in it and a marked up contract, so that when something happens, you could go back to that reference file and you've got your answer, you know where to look something up. So that's super important. I can tell you that not all realtors do that, but I can tell you that the ones that do are usually more successful. They're also able to give their clients a higher level of service, which of course results in dollars in your pocket. So it's very, very important that you know your contract. So we'll get started. We've got a couple different versions. We have the regular contract, which I'm going to use for our class today. We have the as-is contract, which has the warranties and guarantees taken out of it. And then we have a whole menu of related addendums that are listed on the last page of the contract that you can also attach to the contract and use as a part of it. Florida Realtors also has some miscellaneous forms in their forms menu that you can also make a part of the contract. For example, there's a cyber fraud disclosure form. If your broker doesn't have one and you're not using it already, it's a good one to get and use and put with your contract. And we'll talk about that towards the end. And some other things that are useful in there that you can also use. So good. So we'll start at the very beginning of the contract. And first of all, under the seller, how do we know who the seller is? Well, the best way to do it is to go to the county clerk's office, or you can go through the MLS and link into it. And you want to get a copy of the property appraiser's report from their website. That will have on it a link already to, number one, the tax bill, and second, it'll have a link in the sales record about the middle of that document. It'll have a link to the deed of record in the last sale. You always want to go ahead and get that information and then use that as you are creating your contract. So your seller should reflect whoever's in title. And of course, that should be whomever you're dealing with on the listing side, and make sure that that all coincides. If it doesn't, then when you're at listing, you need to make sure that you ask questions. Always ask marital status. That's very important when we're dealing with contracts because of homestead rights. We don't want there to be a problem right before closing and it can't get resolved because of an issue related to homestead rights. And it's a good idea when you're dealing with FERPA, and I'll talk about that later in the presentation, to also ask the question. Don't assume unless you already know 100%, but you want to ask them, are you a U.S. citizen? Because that could reflect as to how we deal with the contract. It could affect the monetary amounts that the seller gets back, etc. So it's a very important question to ask. If you're dealing with a trust, remember that typically a trust doesn't hold title. It's the trustee for the trust. So when you do the contract, you want to be the trustee for the trust that's signing. And if it is homestead property and it's a trust, then we've got to have them sign. In most cases, they may have an individual right to that property or hold it as homestead. In that case, it would be them as individuals and then them as a trustee for the trust. So you have to think about that. And of course, if they're married, then the spouse, if it's homestead property, they also need to be on the contract. If you had someone that was single when they bought the property, then they got married, now they're selling it, it's their homestead property, the spouse also needs to be on the contract because they have rights to the property, they are entitled, so they have to approve for it to be sold, basically. And if you have any corporate entities that are selling or buying for that matter, this also applies on the buying side, then you want to make sure that you get some sort of proof of authority that they can legally do what they're supposed to be doing. And that could be a corporate resolution, minutes, other documents related to the transaction that you can ask for. Now, on sunbiz.org, or I'm sorry, .gov, sunbiz.gov, so sunbiz.gov, there is a website where you can research corporate entities. And a lot of times they will have documents that are attached to their files, and you can click on those documents. You may have your answer there already, but not necessarily. It's not something that has to be there. But you can click on those documents and look for that proof of authority. If not, you have to ask them for it. And we'll look at that on the closing side a little bit later. What I don't want in your contracts is I don't want anything that's not factual. So it can't say owner of record. I've seen it say as a seller per MLS listing. You've seen it too, so it's all over the board. We actually need facts for the blanks that we're filling into the contract as you do your prompts on your computer. On the buyer side, one of the things that I see often is we have a buyer that is on the contract. They don't qualify for the transaction. So then we've got to bring somebody else and make sure at that point that that person is added to the contract. They will be entitled. They will be a buyer now. They will be on the mortgage. So they've got to be on the contract. So you want to do an addendum to add them on eventually after that happens. In the next section, this top section, which is the property description, and here we have a street address. We've got a county, we have a tax ID, and we have the legal description. So most of this information is going to be on your property appraiser's website. And the legal I want you to get from the warranty deed, only because on the property appraiser's website, that's only as good as a person that inputs it. And a lot of times they don't have room for a long legal, so it could be abbreviated and we don't know what it says sometimes. So it's very important that we get the actual legal. If there is not enough room in your prompts when you're filling in the legal, or if it's 3 pages long and you don't want to proofread it, you could always attach a copy of the warranty deed as an exhibit to the contract to reflect the legal description, and that way we'll have the proper legal. Again, in these sections, I've seen things go all over the place. I've seen it say per MLS listing. I've seen it say owner of record, or tax ID number, all that information. And we actually need these blanks filled in because we are comparing one to the other and verifying this information on the title side. If your seller has property that is being cut out of another property, so they have land, let's say they're selling part of it, or maybe they have a home with 3 lots that are tied to it, but they're only selling the lot where the home is. Make sure that you're very clear on that. If the seller has to get, when it's meets and bounds description and they're doing a cutout, if they need to get a surveyor to come in ahead of time before the closing to figure out the legal, then they'll need to do that. So consider those things in the process of it. And it's always a good idea for the seller to alert the county property appraiser's office that it's being done, so they're aware that they'll need to do a division of the tax ID in the future. That's going to be under a different tax ID when it gets sold. The other area, we're going to go down now to section 2, the initial deposit. When I look at contracts, if I were to audit some contracts right now, many times there's a couple deficiencies that I see over and over and over again. One is that the earnest money deposit was not paid on time. The other one is that if it's a condominium, the HOA docs were not presented to the buyer at the point of contract, because remember, the buyer has 3 days to review and then cancel the contract if they don't want to take on the covenants and restrictions and other items related to the development. The other is that, and I'll talk about these things later when I get to those sections. The other is that the seller should be providing to the buyer and the closing agent, so Supreme Title, a copy of their old survey that was done at their closing and a copy of their old owner's title insurance policy, and that's a requirement of the contract, and that has to be done within 5 days from the effective date. I'll go more into that and also why in a moment when we get to those sections. So the deposit, we've got a couple different sections under 2A in the contract. And of course, if we are saying that it's going to be there, it's blank and it's going to be there in 3 working days, we've got to make sure it gets there in 3 working days. And if it gets there on a holiday or on a Sunday, and of course it gets to the next business day at 5 p.m. So if the the deadline is on a Sunday, and we can't do it on a Sunday because it doesn't count, then it goes to a Monday, as long as it's not a legal holiday, and then it goes to 5 p.m. on that day. So just remember, it can be extended out for holidays and non-working days. The other section in here on 2A has to do with who is the escrow agent, and that's saying who is holding the money for that deposit. In most cases, it's going to be Supreme Title. So the buyer will write the check to them, they'll put it in their escrow account. In order for them to hold it, they have to have written instructions to hold the money. The contract in this section serves as the written instructions to hold the money. So it's very important that whomever will be doing the closing ultimately, that reflects the name in the contract. If a third party, let's say that they're going to have their attorney hold it, or maybe another broker wants to hold the money and that's agreed to within the parties, that's fine. We've got to have their information in here as the escrow holder still. But remember that when it's time for closing, they'll need to supply those monies by wire transfer before the closing, so Supreme Title has it in their account to disperse. Or if it's done by a check, it has to come in 10 working days before the transaction happens, because the contract requires that the check be deposited, cleared, and collected funds provided for the closing. So we've got to have time to cash it out basically and make sure that we have collected funds when it's time for the closing. So super important. In this next area, there is a time under number 3 for time for acceptance as far as for delivery. And of course, we want to make sure that we're meeting those timelines in there. And then we have a number 4 is the closing date addendum. And one about the middle of this section for closing date, there's a section in there that talks about CFPB disclosure requirements. And what that says is, and this is on 5A, and what that says is that if for some reason the lender is not in a position to disclose the closing disclosure, which is required through federal guidelines to the buyer, 3 to 7 days, depending on how it's delivered, then the contract can be extended not to exceed 10 days into the future. So this is an automatic built-in extension that's already within the contract. But remember, it can't exceed 10 days from the original closing date that's in the contract. So we have to be careful that if they need more time, it's going to go past those 10 days or exceed the 10 days, then we've got to make sure that we still do an addendum to the contract. So, and if you have nervous buyers and sellers, or we don't know how long it's going to take, then go ahead and just do an extension. It doesn't hurt anything, and it'll give you another 10 days later on that it could be extended if they can't disclose. And then under 5B, we have a force majeure clause, which which kicks in also as a contract extension. When we get to that section, we'll go over that clause and talk about all the things that it covers. The next area I wanted to mention is in the financing area. And financing area is a couple different sections. We've got 8A, which is buyer is financing, but there's no loan contingency. So, or paying cash. So they either have to come in with cash or loan, and they have to close no matter what. Then we have 8B, which has a loan contingency, and that means that that buyer or that transaction is contingent upon the buyer getting a loan, but then they must follow all the deadlines and guidelines within the 8B section. We're going to go over some of these. First of all, they must get loan approval within 30 days of the effective date. And it says all over the contract loan approval in this section, but it's truly not loan approval. It's loan approval with a contingency. And this is one of the things that they have discussed in the FIRB committee to rewrite this whole section, because it's not real world language. What it's saying isn't what it's truly doing. So they've discussed about rewriting this whole thing, and I think it will happen. Don't know yet. They're still figuring it out and voting on it, but this is one of the big sections that'll be hopefully rewritten. So 30 days from the date of signing this contract, from the effective date, they must get loan approval. There's contingencies, which I'll go over in a moment, that cover those periods. The buyer must actually apply for the loan within 5 days of the effective date of the contract. So that's going to be done right away. and that's called making mortgage application. That's in section 8I. And then it also says in that clause that if the buyer has to sell a piece of property in order to buy the property that they're contracting to buy, it's not deemed to be loan approval. So remember that, because that's saying, even if we get that 30 days contingency loan approval, if they have to sell a piece of property, it's not considered loan approval. So you could do two things. You could wait till the 30 days and all parties decide at that point to march towards closing, or you can pretty much at contract write into a contract stating that all parties acknowledge that because the buyer has to sell property to buy the property, then of course it won't be considered loan approval, but all parties agree to move towards closing anyway, just like if they had received loan approval. And there's a clause in the contract that covers that later, but that's at 30 days, which I'll go over in a moment. The other thing that it says in section 8I is that buyers' failure to use diligent effort to obtain loan approval during the loan approval period shall be considered a default under the terms of the contract. It doesn't go in and get specific as to what is diligent effort. So it's kind of up in the air, in my opinion. But just know that lenders are keeping track when they're requesting information, when they get it back. Everything has a date stamp on it. So if they had to prove that the buyer was lagging in the process, they could. And I've never seen anybody challenge that, but it is in the contract just to let them know, hey, you've got to do things pretty quickly. And of course, if you have a client that is slow moving, you need to let them know that we're under a time limitation. So we've got to get things faster to that lender, or whomever's asking for information. It's got to be pretty quick because they could end up holding up the transaction in the process of it. Now in clause 8, and this is I3, which is probably going to be towards the bottom of that second page or top of the next page. On there, it states that once the buyer obtains loan approval, they must give written notice, and that's a key, written notice to the seller that they received it. So that's at the point where they're saying to the seller, hey, 30 days haven't passed and I have loan approval, so we're good. We're going to march towards closing now. Now, if they do not give written notice, two things can happen. The parties can waive the loan approval and move towards closing just like if nothing had happened, or the seller can also terminate the contract on day 31, 32, or 33. So we're up to the 30 days and they've given no notice of anything, no communication. Then the seller could decide, okay, I'm going to hang out here and go march towards closing just like if we got it. Or, no, I'm going to cancel this contract on the 31st day, give them their deposit back, and I'm going to take this backup offer that's cash for more money. And I'm going to go with those people now. So that's an option that's built into the contract if they don't give proper notice. And then that rest of that section goes over and identifies different things that could happen and who gets a deposit back depending on what could happen. Now, that means that if one party doesn't act and they don't do what they're supposed to do, it's telling us who to give the money to. However, because we have to have, Supreme Title has to have, because they're holding the escrow monies, written notice from the parties to release the monies, then we still need to get what's called a release of escrow signed by all the parties that they need to have on file in order to release the money to the party that it directs us to release it to. And if for some reason they're arguing, this could go to mediation. If we get mediation notice, and we do have the right to hold the monies as far as through the mediation notice. If they're arguing and we have no mediation and they're still arguing, we can't keep the money forever because now the contract's terminated. We have no closing. So we actually have to give that money up to deposit to the clerk of the circuit court, and they'll have to fight it out in court. With mediation, there are fees related to that. There is a cost related to it. With fighting it out in court, you could have attorney's fees, you could have court fees that'll be taken out of the money. And some of those fees could be $500 to $1,000 easily up front. So they could lose a big chunk of that money if they're arguing about it. So if we have little money sitting there to fight over and they're arguing about it, we've got to give them some good advice and let them know, hey, here's what could, worst case scenario, what could happen. You could end up losing all the money. You can get nothing. You could end up paying for attorney's fees, whatever could happen. So just let them know about the things that could happen. So hopefully they'll sign that release and we'll be done and go on to the next transaction. So that's our financing clause. Then the contract has a whole section built in to clarify who is paying for what in the transaction. So we have 9A are the costs to be paid by the seller. And then we have 9B, which are the costs to be paid by the buyer in the transaction. So anything that's different from those clauses that are pre-written already in there, make sure that it's clarified in the other sections in those clauses or on some sort of addendum to the contract to clarify anything that's opposite of what's already written in here and what's decided to be done. In some cases, for example, we may say, you know, seller will pay for 3% of buyer's closing costs. Well, that's got to be written either in here somewhere or on an addendum, so it's clarified that we're taking closing costs and then we're paying 3% and putting it on the seller side. So we know how that relates to the actual closing cost. In some cases, we can put a flat credit. In most cases, we actually have to move specific fees that they were paying for and then add them up to the total amount of the monies and the percentage that's being paid. So this has to be very clear. Under 9C, we have title evidence and insurance in that area. And this is the area that's created when they required title insurance many years ago as a part of this contract. The whole reason for requiring title insurance in the contract is they want to make sure that the contract and the parties take the position of the seller is showing clarity of a status of title to the buyer in the transaction. The buyer gets a commitment giving updated information on the transaction, and the buyer gets an owner's policy protecting him or her or them as the owner of that property once they purchase the property. And why is that there? For peace of mind. We want to make sure that the investment that the buyer is putting into the property, whether it be initially or throughout time, that they have peace of mind and they are protected as far as having status to that title. And at the time that they closed it, they had clear title to the property. So they go to sell it later, they don't have an issue of a problem, or if somebody comes up and there was fraud created or other things that could come into play, then they're protected and they can file through that title insurance policy, a title insurance claim, and be protected for their investment in the property. So that's why they created that many, many years ago as a part of the transaction. In 9C, it requires that the buyer get, if clause 8A, which is cash or no financing contingency, if that clause is checked, then the buyer must get a commitment 5 days prior to closing, before closing. If any of the other clauses are checked, then the buyer must get a title insurance commitment 15 days before closing. So it's either 5 days or 15 days. That happens, the way that that happens is the title company, Supreme Title, will research the property based on the contract information that you give them. They'll do what's called a title search together with us, the underwriter, and they will then create a title commitment that then goes to the buyer. And also the buyer has a lender, their lender will want to be protected too, and they'll get a loan policy in the process of it, and they'll also review it. But that's the whole reason for this clause, for that delivery of the title commitment. The commitment is a document committing to ensure title in the future. It's saying how they're going to be protected, how much they'll be protected, etc. And I hear some background noise. If you unmute, whoever's live, if you unmute your line. And then further on in this clause 9C, right after what I just talked about for the delivery of the commitment, then we have a section that says a seller has an owner's policy of title insurance covering the real property. A copy shall be furnished to buyer and the closing agent within 5 days after the effective date. And that is talking about when the seller bought the property, if they got a title insurance policy protecting them, they should be providing that to the closing agent and also the buyer within 5 days from the effective date of the contract. The whole reason for this, as far as why it was put in here, is number one, for clear upfront disclosure between the parties. Second, if we have a title defect that comes up once we do that title research from when that closing happened, let's say somebody made a mistake on a document, we need them to correct it. Maybe they've died, maybe there's no probate, so it creates a big mess. If we have a copy of the prior policy, we can go back to the prior underwriter that wrote that policy and ask for a letter of indemnification. And in most cases, they will, if it's their error, they're going to give it to us. And that indemnifies Supreme Title to go ahead and do the closing and to be able to insure. And that other underwriter will go back after the fact and fix the problem. So it allows us to move forward and close and get paid in a situation that could be impossible to get over or very timely to get over. It allows us to move forward. And the other reason why that's there is there's a Florida statute that says that if a transaction closes within 3 years of the original closing date, of the date of that policy, then we must give what's called a reissue rate, which is a highly discounted title insurance rate. And in order to do that, we must have a copy of that prior title policy. So those are all the reasons why they put that in there. So it's all good things. When you're at your listing appointment, you want to ask for this. You want to also ask for the old survey because, as I'm going to show you in a moment, the old survey also applies to these same timeframes and clauses. So you want to ask for this. So if they do not have it, if they lost it, whatever, or their dog ate it, whatever, you want to make sure that that seller can then contact the closing company, did their closing. If you look on the warranty deed that I mentioned earlier, there will be a prepared by stamp on there. They can call that company and get a copy of the survey and the owner's policy, and then you'll have it. And what I like you to do is scan it, attach it to the MLS listing, and that way it's already there to supply when you go into contract. Because you only have 5 days to do it from the effective date. Further down in the same clause, it also states that when we issue the policy in the end for title insurance to that buyer, it cannot have exception to liens related to chapters 159 and 170 of the Florida statutes. And those are typically municipal liens that could be on the property, service liens for utilities that could be on the property, and other related items like that. So basically, we have to go through and do a municipal lien search in order to comply with this and then issue that policy so it covers all items and doesn't accept out these type liens. That's a newer thing that got put into the contract a couple years ago. Then we have a section right after that where it says check one. And we've got two options in your area, which is the seller pays for the title insurance owner's policy and the title search, and they choose the title agent, or the buyer pays for it and they pay for all the fees. Mostly, traditionally, we see the seller paying for the owner's policy, the buyer pays for what's called the loan policy and endorsements, and the seller pays for the search fee, unless the buyer picks it, but that's more on the rare side. There are different areas within the state where, because of more or less tradition and nothing else, they do it differently, where the buyer pays, let's say. But that's far and few between. I think there's like about 5 counties that do a little bit different. Everybody else is pretty much like in your area when they figure out the cost. There is another provision, but it doesn't apply to us because it's a Miami-Dade Broward regional provision, so it doesn't affect our area. Then we have the survey, and that's on 9D. And the survey has, it's kind of confusing. It has 2 different sections in here. The first says, on or before title evidence deadline, buyer may, at buyer's expense, have the real property surveyed and certified by a registered Florida surveyor. And then it says, if seller has a survey covering the real property, a copy shall be furnished to buyer and closing agent within 5 days after the effective date. And what that means is it's 2 different things. It's saying for this new purchase that we're doing, the seller is going to actually provide the old survey that they have, so the buyer can review it just for informational purposes within 5 days of the closing date, before the, 5 or 15 days before the closing date. The same restriction or same requirement as the title commitment. So 5 or 15 days, depending on which financing clause was checked. The other part of this clause is saying that the buyer has the right to get a survey on the property and pay for it and order it. And that also has to be delivered within that time period of the commitment delivery. So the new survey, they're getting 5 or 15 days. The old survey that we're getting from the seller to pass on, that has to be done within 5 days of the effective date. So two different things, two different requirements. Old survey, just like the old policy, 5 days from the effective date, and that's the one you want to scan and attach to the MLS listing. For the new survey, 5 or 15 days before closing. The whole reason this 5 or 15 days mirrors the commitment is because there's another clause later in the contract that I'll touch upon, which is called the standards for real estate. And if we get the survey, if we get the commitment, and there's a defect in there or an issue that we have as a part of it, then that clause allows us to figure how to work it out or end the contract either way. But it could extend the contract even 120 days into the future to deal with an issue. So it gives us a structure for working out the problem. But in order for that to kick in, if there is a problem, we've got to deliver the commitment and the survey 5 or 15 days before closing, depending on the clause. So that means it doesn't benefit us if the buyer waits till the last minute to order a survey, because we have gone past the 5 or 15 days at that point. So that clause will not kick in because of it. So it's very important that the buyer understands that. And the survey needs, as a matter of practice, really should be ordered more towards the beginning when we order that file and not towards the end. And we could always have many surveyors will want something signed by the buyer saying that if it doesn't close, then they will pay for that survey bill. I had a personal situation on a survey where I had just a hunch that something could be wrong. So I literally ordered my survey the day that I signed the contract, because I knew that, something could be up, and I didn't feel too good about the disclosure that the seller was giving me. And I was correct. The item that I discovered probably would have cost somewhere between $30,000 to $50,000 to deal with, to correct it ultimately. And I can tell you that the seller refused to acknowledge or deal with it. I can tell you that the seller knew about it because of other evidence that I found. So the seller pulled out of the contract the day prior to the closing. The survey was $1,200, and I gladly paid it to the surveyor after that happened, because it could have been a lot worse for me if I would not have gotten that survey and been within the guidelines of the standards for real estate. So it was actually a good thing that happened. Did it hurt to pay the $1,200 check? Yes, but I gladly did it because it could have been a lot worse. I could tell you the property was sold about 9 months later, and they did not disclose, and they didn't do things like they should have. And I could tell that buyer is dealing with those issues right now, only because I live about a mile away from it, and I go by there and I see what's going on. So I know they didn't disclose, and I see the problems that it's causing. So that's why that whole survey clause is in there. Now the contract has an area for special assessments. It's under 9F. Know that these are not condo special assessments, but these have to do with more things that go along with the tax bill. So lighting assessments, other assessments, road assessments, that could be a part of the tax bill typically. And this creates a structure as to who pays for it, how it's done, how it's prorated, et cetera. So if you have any of those, when you look at the tax bill for the property, this is a section where you deal with it. Special assessments for homeowner association dues are dealt with for condominiums and the condo addendum, or the other one is in the plan unit addendum that can be a part of the contract. So this is separate to that. This is just for things having to do with the city or the county. There is a section in here, a whole disclosure section starts on as item 10 in the contract. And the disclosures have to do with many different things. One of the things that we have to be aware of is, as a part of this contract, they did end up adding the permits disclosure requirement. So that means that if there are permitting issues or permits that are not closed out, unless you have an as-is contract and it's right to inspect, then it's different. But the regular contract, they must disclose that information. So this is the first area where we see it. The other thing that has to be disclosed as a part of this is the FERPTA disclosure, which is on it's item 10I in that disclosure area on the next page. And this is in case a property is related to FERPTA, which we'll talk about towards the end in the actual FERPTA clause. But this is when they're a foreign seller and they could be required to pay actual fees or monies related to the transaction to the IRS. It's the Foreign Investment and Real Property Tax Act is what FERPTA stands for. And then wanted to go over to, skip over to the area. And by the way, under clause 12, it talks about all the different types of inspections. So whether it's a termite inspection, general property inspection and repair, wood destroying organisms, repair. So all sorts of related inspection areas. I wanted to skip over to clause D in that section. So that's 12D. And that talks about the permits issue. And the permitting issue is something that's a hot ticket nowadays. Why? Because, sorry, the slides are kind of running by themselves. Let me go back to where I was. Okay. The permit area I wanted to mention, the permitting issue is not a title insurance issue, so it's not covered through title insurance, but it's something that has to be done within the inspection period. So you have the typical 15 days from contract signature inspection period, unless you change the date to something else. The permits inspection search must be done typically within that time frame. If the buyer wants to do it on their own, they can. They would contact the county and go through the process of doing it. It's more or less a due diligence thing that that buyer has to do within the inspection period. If you have a home inspector that does it for them, find out. That's something that some home inspectors do it as a part of the process. Excuse me. And or Supreme Title also has a company that the buyer could pay to do that permits inspection and the process of it. The permits inspection means that I'm buying a piece of property and I'm checking to see if something was permitted and left open, so it was never closed out and approved to make sure it meets codes. Or maybe they did an improvement on the house and I'm wondering, well, did that extra bedroom that they added on, that addition that they added on, was it ever permitted? Are they telling me the truth and the disclosures? So that's my due diligence to check those things out. If it's a regular contract and the permit was not closed out, that could be an issue. It could cost money to the seller. So we want to make sure that we address it and go back to the seller with that items. And again, it has to be within the inspection period. And examples of that could be, I've seen it where an AC was worked on, so they opened the permit. The contractor leaves the job. The homeowner has somebody else finish it. They were not licensed. They never closed out the permit. So we're closing now 5 years later, and we check for the permit and it's open. Well, that has to be closed out. So the county will come back out for a fee, re-inspect. Well, what about if it doesn't re-inspect? I've had one in a transaction where they did the re-inspection, it didn't meet code, and it cost them almost $10,000 to redo everything at that point. Enclosed carports, as you know, have a habit of appearing over weekends without permits. So that's something that I've seen over and over that are issues. Again, if it's an as-is contract, it's different. They can disclose it, it's not permitted. The buyer could take it on and accept it that way. So it's a little bit different. But when it's a regular contract, we do have this requirement as a part of the contract. So super important. And again, those things are not covered by title insurance. So it's a due diligence within the inspection period for the buyer to do. Well, good. So now we're going to skip over to the standards for real estate that I've been mentioning to you. And you're going to go to clause 18 in the contract. And clause 18 has a couple many different sections. The ones that I kind of wanted to hit upon are the first couple sections, which are titled standards. 18A is title, and that has a couple different sections: title evidence, restrictions, assessments, and limitations. And then the second part of it is title examination. And then 18B has to do with surveys. 18C has to do with ingress and egress. So once that survey is disclosed per the guidelines, so 5 or 15 days before closing, And once the commitment is disclosed and there's an issue, these clauses kick in. So if we have a title defect situation, these clauses kick in and they talk about how we move to resolve them. And basically, once the buyer receives the commitment and the survey mirrors in the same way, or the survey, they have 5 days to, in writing, contact the seller and ask about that issue and ask them to clear it or correct it or make it right. Then the seller has 10 days to respond back about that issue to let us know how they're going to move forward to clearing it and making it right. Or if they're not going to do anything, we need to get out of the contract and end the contract. Now, in cases where we have a defect that's unknown, which are most of these, it doesn't matter if it's this buyer or 10 buyers later, it's still a defect and a problem, so it has to be fixed. So because of that, the contract has this section has a clause in it that will allow for the contract to be extended, not to exceed 120 days into the future, to deal with the issue and the problem. So that's very important to know. And an example that would be, and this has happened over and over in my 38 years of being in the business. Let's say that I'm buying a piece of property. I do my survey, I do the title work. The survey discloses that we have an encroachment through the actual home of utility easements. And it turns out that these people that had the home bought several lots from the builder, but in the plat from the builder, it says that every lot has a 10-foot utility easement around the perimeter of the property. So that means that if I put a house in the middle of the lot line, I've got a 20-foot easement going through the middle of my home. That's a problem. So the way to clear that is I have to go through the application process, and I go to the county or the city where it applies for the property, and I have to request for them to vacate these easements, to take them away legally, which means we have to go through a meeting, a hearing process. There's a whole procedure that we have to go through. It costs money. It's not quick. It could take us a couple months for that to happen. So in that case, that's something where we could use that. Because again, it doesn't matter if it's me as the buyer or 10 buyers later, it's still a problem. They still can't get clear title that way. So that's why these clauses are built into these sections. The survey is the same way. I mean, I just gave an example of a title and survey related issue, but let's say on the survey that I've got a utility easement in the backyard and there's a shed on it. And I decide as the buyer, well, gosh, that's a pretty big shed. I don't want to lose my shed. If they have to do work in there, what am I going to do? I can go back to the seller and let them know there's an encroachment there and I need that shed removed to a place out of the easement, and then we'll close. So that's an option that I have. So that's the way that you deal with those type of things for these standards for real estate. Right after the ingress and egress section, there is a place under 18D for lease information. And basically that means that if we have leases on the property, that the seller must provide the buyer and also the closing agent copies of leases, copies of deposits, insurance policies, anything monetarily having to do with the leases. And that must be done 10 days prior to closing. So very important. And in the next sections, I wanted to go over 18F, and that's the time of the contract, time factor in the contract. And that has to do with how we deal with a contract in time period. So it says, number one, time is of the essence, which we've got that in other sections of the contract. And it says, other than time for acceptance and effective date as set forth in paragraph 3, any time periods provided for or dates specified in this contract, whether pre-printed, handwritten, typewritten, or inserted herein, which shall occur on a Saturday or Sunday or a national legal holiday, shall extend to 5 p.m. the next business day. So that's where I mentioned that if we can't do what we need to do because of those date restrictions, then it goes to 5 p.m. on the next business day. Right after that, we have the force majeure clause. So that's basically when we cannot perform. Title insurance services, financial services so far, and of course you'll need to go to your local, state, and city or county guidelines for your specific areas. But in my area so far, they're considered essential services. So a title insurance closing agent can be open and still function because it is as a part of a financial essential service. But this section talks about for reasons that we may not be able to close, what happens. So typically once the time period is over, we have 7 days to close, but there's a time limitation not to exceed 30 days in the time period. So this is something that when something happens for the reasons stated in this section, and it says force majeure means hurricanes, floods, extreme weather, earthquakes, fire, other acts of God, unusual transportation delays, wars, insurrections, acts of terrorism, which by exercise of reasonable diligent effort, the non-performing party is unable in whole or in part to prevent or overcome. So that's how they've defined it so far. We may see this changing in the future because of the current times. We'll see what happens, but that's your definition for force majeure. And then in that same section, under K, there's a section for prorations and credits. And if you're wondering how something is prorated as a part of the transaction, that's a section to go to. And then I wanted you to skip over to section S in that same section that talks about collected funds. And as I mentioned before, the contract requires collected funds. That's why we have wire transfers typically that are done as a part of the closing transaction. If we ever have to deal with a check, a cashier's check, we've got to have it in plenty of time to collect it. So in other words, we need it a good 10 working days before so that the closing agent can deposit it at their bank. It has time to clear, and then it's deemed collected. So by the time we close, the money's sitting in there just like a wire transfer. Cash is our collected funds. However, we cannot be liable for a large amount of cash, so we won't accept cash. If I had somebody bring me in a suitcase $98,000 worth of cash on a Friday evening one time, and boy, did we have a lot of fun that weekend. No, just kidding. What happened was I had to say thanks so much. I had to get permission to close an escrow from all the parties, and then we had to end up having to go to the bank on Monday and then wiring me the money for the transaction. Excuse me, my allergies are bad today. The next clause I wanted to talk about was clause V in this section, and that's the FIRPTA tax withholding clause. And like I said before, FIRPTA has to deal with a foreign seller that's buying a piece of property. And it's a mechanism for the IRS to collect monies from a foreigner that doesn't pay US income taxes. We do have a class on FIRPTA that we could do at some point in the future. And FIRPTA basically has several exemptions where they can get out of paying the money or be exempt from paying the money. But if not, and it does talk about in this clause about some of these exemptions, the buyer must give written notice to the, excuse me, let me rephrase that. The seller must give written notice to the buyer in these FIRPTA transactions to make sure that they will comply with the IRS guidelines. And some of the guidelines are written where it puts certain responsibility on the buyer's side. There are two different exemptions where the buyer, in order for the seller to be exempt from paying in the transaction or partially being exempt, the buyer must live in the property for the first 2 years as a main residence or one of their relatives. That's part of the exemption. There's another piece to it too, but that's part of it. In that case, if an investor is buying a FIRPTA property and it's deemed exempted, but the IRS finds out they're just flipping the property, they were an investor, they can come after the buyer for those monies. In worst case, 15% of the sales price has to be collected and paid to the IRS, so they could be liable for 15%. The other reason you want to ask up front about FIRPTA when you go to your listing appointment is, what about if you have a seller that can only sell the property if they have an exemption where that buyer is going to occupy the property as main residence for the first 2 years? Or maybe you have a seller that doesn't have an exemption, but the monies aren't there to actually do the transaction. They would have to bring money to the closing. So it's super important to discuss that if you have if you don't really know them or you don't have an idea that they're not a foreigner. By the way, I did a FIRPTA class not too long ago, and one of the realtors came up to me afterwards and questioned me about the different exemptions. And I said, well, why are you asking me all these things? We covered them in class, blah, blah, blah. She seemed to ask a lot of questions. Turns out that she just sold a piece of property. She's a citizen of France. She did not have an accent whatsoever. I had to bet money if she was from America, I would say she was. But she said that they never asked her and they never collected the monies, and that she did owe the monies. So just remember that, you never know. If you know 100%, make sure that you ask them in the process of it. Then, so that's our main body of the contract. And then we have the section for the addendums. Probably the most popular addendums you're going to deal with are going to be the condominium rider addendum, homeowners association addendum, the appraisal addendum, but there's many to pick from in your menu of addendums here to use. So just remember, if you use any addendums, you must mark them and then provide copies to the closing agent, Supreme Title, and also to the lender. They'll need copies of them as part of the transaction. And then the other piece of it is make sure that you have signatures on your contracts and initials as required. And I know that in most cases you're having everything e-signed, so that's a good thing. You'll know it wasn't done, but that's very important too in the process of it. So there's our contract. The last thing I wanted to mention is, if you are not doing a cyber fraud disclosure at listing or before you put somebody in a car to go look for properties, the Florida Realtors does have one in their extra forms menu. It is not a contract addendum. They have talked about putting it as a clause in the contract, so that could be something that happens later on. But make sure that you have a disclosure sign at listing, or if it's a buyer, before you put them in a car to show them properties. Why? Because if there is a breach in your transaction, I want you to be able to show, if you get sued or somebody's trying to get liability from you, I want you to be able to prove that you told them about it ahead of time. And by having that disclosure sign, it takes care of that. You can also take sections of the disclosure and put it in your email signature line. You can state the information in there. So every time you're emailing back and forth, you're talking about cyber fraud and wire fraud in your emails. Well, great. So hopefully this was helpful to everyone that's on the call and you got some good information out of it. Again, to first of all, protect yourselves, but then also pass along this information to your clients. And if for some reason, by the way, Rose, do we have any questions in the chat box about anything?
I actually don't see anything.
Okay.
There was one comment from Marty, and he said back to 2A, you do not use TBD.
That is correct. Never TBD.
Good job, Marty.
Never.
So that was really it. And
yeah, because TBD is not
guys, I gotta
TBD
say,
is not
y'all
a
are
fact.
slacking a little bit, because we got one person that told us a class that they would like to see.
Does anybody want to take a stab at putting another idea for a suggestion for a class? All
You
you
get
have to
a $20 gift card.
you get a chance at a $25 gift card.
Yes, you get a
At the bottom, you can put chat and you can put something in there. Marty wants to know where you get the cyber disclosure.
It's in when you go into the forms in your computer that are licensed to the Florida Realtors. There's a section about, it's not in the contract section. It's under the additional miscellaneous forms. It's in there, and it's called the cyber fraud disclosure. And it's sitting in there as a form. If you can't find it, let us know. I could send one to Tracy, and we can get it in your hands. But it's in the forms, the extra forms menu.
I can send it to you. Give us 1 second, but we have the next question from Stacy Holdsworth. If the seller doesn't have a survey, do they have to get one, since the buyer will be buying one? The buyer.
Let me clarify that. So if the seller got a survey when they purchased the property, they're required to pass it on as the old survey. If the seller did not get one in their transaction, then no, they don't have to pass it on. And if the seller didn't get title insurance for that matter, there's nothing to pass on either. And what I would do is I would clarify that in an addendum, because in most cases in today's times, typically they do have a survey and typically they do have an owner's policy of title insurance.
For sure.
So I would clarify in that way it's not questioned later and everybody knows what's going on.
Okay. And I think Johnny has a question, so I'm gonna unmute her really quickly.
Okay.
Go ahead, Miss Johnny.
Hey, Johnny, you're on.
I was going to put a request in for another class.
Great.
Oh, just do you see the chat?
I can't find it.
It's what, take
So
your mouse.
if you move your mouse around on anywhere in the screen and that bar comes up on the bottom.
Do you see it?
Yes,
Okay.
I've got
That says
share.
chat.
I don't see chat.
It's at the very
may have to-
bottom.
Basically,
there's-
let me tell you what it is. I would like that class on that FIRPTA, the foreign
Oh, the
investor.
FERPTA.
Oh,
It
FERPTA,
seems
yes,
to be,
yes, we can do
Let's
that.
soon.
Yeah,
We
Stacy
may-
actually just
John.
suggested that as well.
Yeah, we may see, by the way, a lot of those coming up because the whole Brexit thing with the UK, it may
Johnny,
end
I'm gonna
up
mute you
as,
again. Sorry, go ahead.
can you hear me okay now? I'll start talking
Yeah.
again. So we may see a lot of FERPTA coming up in the near future because of the whole Brexit issue with the UK. It may be more beneficial eventually, not today, but eventually, for the UK people to cash out of their Florida investments because we have so many on the East and West Coast and in Central Florida around Disney and in South Florida that a lot of them may cash out those properties and then go back and invest in the UK. So we could see an influx of that happening. So that's a good class in case that happens.
fantastic. Any other questions, guys?
Anyone?
We got a great class. Somebody said that was a great class.
Yay.
Thank you, Stacy.
Of
That's
course,
wonderful.
we're glad to offer these to you.
So we'll give you a minute or two. There's 20 participants. We've got a bunch of people who already advised what class they'd like. Anybody else want to throw their name at the bottom of the screen? Just put in chat.